Hi, Bill Henshaw here again, Constitutional Coop Headquarters. This is some more good news. And what I'm doing now is starting a series on the documents I do, particularly in my trial court packet. And all they do is win and win and win. The bill of particulars I'm going to read from you here now just won this case January 25th, when with the hearing pending on the ensuing Friday, the 28th, a jury set up hearing, they decided to cancel out and dismiss all charges, and that's what got done. It should have been with prejudice, but we filed these documents, or attempted to file them, and set an unopposed record, which we're now going to come back and burn their ass. And they realized that they simply couldn't go to a jury trial. Among other things, people, you got to realize they don't have the courtrooms for this. I mean, they get hit, and we hadn't got as far as filing these yet, but we had almost 600 jury instructions. Now, that can't happen. I mean, for example, the trial of O.J. Simpson, it would have been lucky to have 40 to 50, maybe, on both sides. I've got almost 600. By Easter, it may be 7, because we have a right to get our theory of the case to the jury, one that can rule on the facts and the law. That's the ultimate check and balance on these state bar association attorneys that have complete control of the system on behalf of their, bosses, the New York banksters. But if we get there and get them our theory of the case, it won't even be close. In fact, one of the documents you also get with my materials, and send me an email, youwinnincourt@gmail.com, is an opening statement to the jury, which we're entitled to make. The DA has to go first, and then we make an opening statement. And we start off by saying to the jury, it's going to be astounding at first that we're here demanding the right to trial by jury, but we can't actively participate. Let me tell you why. In the space of about a 20 or 30-minute speech, you end up and you say to the jury, given what you just heard, you don't even have to go back in the jury room and deliberate. Find me not guilty. Have a nice day. That's how strong our position is here. And it starts out with the bill of particulars, which they've never acknowledged one, let alone answered it. And they have the sworn duty, the local dumbass, to sustain the government's burden of proof on jurisdiction and venue, which can't be done. If they attempt to do it on the record, they convict themselves of treason to the Constitution. That's the U.S. Supreme Court saying it, not me, by the way. Case is called Collins v. Virginia, 6-week, 624, I think. I'll get you the case, but that, 200 years old, but very powerful case. And the last term, the conservative just cited it in 2 different cases. I mean, they know what I know, and they're going to have our backs now for the first time in probably over a century when we get our issues to them. That's what they're saying behind the scenes. It's a powerful message. So that said, the bill of particulars, and it's not that big of a document. It's 10 or 11 pages right now. I could have made it a lot longer. But you ask them up front a lot of questions, and we have the right to know. And it's more than a Sixth Amendment issue, by the way, but nature and cause of the accusation, which is jurisdiction and venue, elements of the crimes allegedly committed, so we know what it was that we supposedly did, and most importantly, the identity of the injured party. And there must be one in a criminal case, otherwise there's no jurisdiction. And then what that does is defeat our unopposed right to confrontation and cross-examination. And you're going to be stunned when you learn who exactly it is we're going to be subpoenaing in there if it comes to that for confrontation purposes. That's how powerful this is. One document. And we start right out with it, and we say, number one, what is the jurisdiction and venue of the alleged causes of action? In this case, keep firmly in mind those mentioned in Article 3 of the Constitution. What we're saying right from the get-go is we know we're not in a judicial court. We're in an administrative tribunal, and we can prove it. The problem with that being we haven't made any voluntary, knowing, and intelligent waiver of rights. We have a right to a common law jury according to the course of the common law that rules on the facts and the law. That's what beats these bastards. If nothing else does it, that's the ultimate check and balance, and has been going back as far as the Magna Carta 800 years ago. That's what we want. That's what they can't give us, and won't even attempt to do it. So you either get a dismissal, as I've just done here, or perhaps a sweetheart plea bargain. And if we get together, with the relationship here and to get my materials, I'll discuss with you, because you can pretty well safely accept almost any plea bargaining offer. You just have to know how to do it, and it won't come back and hurt you at all. But the unopposed record that we're going to set or would have set in the trial court is going to bite them in the ass. And this is the way we start to make changes. Not only is it going to be a good chunk of change, even in a traffic court, but we want them to change the way they do business so this doesn't happen anymore. It's simple. It really is, once you understand the truth about the Constitution and the original intent of the framers. And wouldn't you love to have known that in high school? So would I 50 odd years ago, and they didn't teach us a damn thing. And I'm right outside of Washington, D.C. for crying out loud. Imagine what I could have done with that information, but better late than never. I found it, I've learned it, and I'm going to teach you how to do it and take control of your lives and take it away from this BS government that we have. That, I mean, it's astounding. The government doesn't exist. We can prove every bit of it, and shouldn't be there. We want to get back to what we had prior to the war between the states. Now, that wasn't perfect either. I'll concede that, but it was the best government ever created. And if we get back to that point, and the free sovereign body politic, and I make no apologies here, free, white, male, 21, that's the way it was. And that's the way it is in common law, because you can't, and for example, and this is not anti-Semitic, by the way, those of you out there who think it is, because when's the last time you heard of a sheikh or a sheket even being allowed to immigrate to Israel, let alone become a citizen and taking a part in any part of government, let alone the Knesset or the Israeli Supreme Court? Doesn't happen, especially for those of German heritage. That's how common law works. It goes back to the 12 tribes of Israel, in the Old Testament, and it is what it is. Now, if we get back to where we were, there is a way to make changes like that, but the 14th Amendment not only wasn't it, the 14th Amendment has never existed, and we can prove that also. It's not there, and that's the only citizenship that they recognize these days, artificial corporate citizenship, and you're a subordinate citizen. All persons born and naturalized in the trust known as the United States and subject to the jurisdiction thereof are United States citizens, capital U, capital S, or small c, and of the state in which they reside. That doesn't work. They can't prove any of it, and that's what the Bill of Particulars says. We want to know exactly how you think that we're subject to your jurisdiction. It's not there, and we can prove it in spades. Damn, it just really is. In fact, I go on and I say, number 3, in what way does the person, parenthetically person, quote unquote, capital letters, of the accused attached to the statute sought to be enforced against them? They have to prove, for example, that you're a person, for example, required to have a driver's license to drive on the roads of this state, in a vehicle of a type required to be registered. And they can't prove any of it. And the lie comes in immediately because person in the statute is always in small letters. It should be in capital letters. That's a corporation. And I used to have, and I wish I still had, a 12-volume set of I can't think of the right title of it, but from the Office of the Attorney General. And that's their guidebook as to what they do and how they do it. And they recognize the capital letters equals corporate entities. And you'll notice your name is always in capital letters. You have a zip code attached to your address. And it just gets worse than that. Zip code, by the way, it's also comes from federal, regional, martial law rule. And I got a friend in Missouri right now that's actually won his case already. They're just too ignorant on the other side to know it yet. And we're going to come back against them in a major lawsuit. I'll keep you up to, not a lawsuit, but a demand for redress of grievance. We're never going to see a jury, and neither will you, and you won't need to. We just file a claim for petition for redress of grievance. I'm going to do another video about that. I'll show you what I do. And we make it clear to them the record we're going to have, and it's not just your case. As I had cases of decades worth relevant admissible evidence, including my South Carolina felony case, where I was sentenced to a 7-month vacation as a political prisoner by an idiot black robe bastard here in California. And I get there, it took him 2 months to get me across the country on 4 different federal unmarked military aircraft. And my God, they could have got Bill Gates or Elon Musk to get me here probably in about 90 minutes on one of their aircraft. And I get there, and the first meeting we have at the hearing, I'm there manacled hand and foot in a red jail suit, and they read the charge, practicing law without a license, which is a felony there. Place I've never been, by the way, never had set foot prior to this episode. And I laughed. And I said, the problem with that is I don't practice it. I get it right the first time. And then the judge, who I think was one of the good ones, said, well, we have to check you out and be sure you're competent to represent yourself. If I could have thrown up my hands, I would have. And I said, oh my God, Barfetta, Beretta v. California, Judge 422 U.S. 806. The problem with that is that the Supreme Court ruled in Barron v. Baltimore, 7 Peters 243, 1828, the Bill of Rights doesn't apply to the states. Stun them into silence. I'm the one there, manacled, hand and foot, red jail suit. They're the ones in trouble with the law, and everybody knew it. That's the power we're supposed to have, and what I'm going to teach you how to get back and teach your children and your posterity how to do it. So but I should have been home the first week of of April, but I didn't get back until August because behind the scenes, and I can't probably prove it now with direct evidence because the judge unfortunately passed away. The last hearing I was at, she showed up and had very aggressive treatment for brain surgery, and she was dead 4 or 5 months later. I didn't hear about that right away. But I was going to name her and say, don't worry, just tell me who told you what to do and why. Because I was being investigated at the same time, behind the scenes by the feds trying to make me out to be a domestic terrorist. And they couldn't do it because that's not who the hell I am. And these days it's gotten even worse. That idiot Merrick Garland, thank God he had done the Supreme Court, ordered the director of the FBI, whoever it is these days, to go after parents of children in school who were opposed to critical race theory and make a case against them as domestic terrorists. That's how fucked up this government is. My God, it just doesn't stop. And I may be lucky to have gotten out from under it, but I was so good. I mean, they just didn't know what to do with me. And you don't have to be near as good as I am, by the way. The ignorance is colossal on the other side. Especially with state bar association attorneys and judges. Went to law school 4 to 6 years, didn't learn a damn thing there either. Or if they did, they keep it to themselves. But it's that bad. And we can beat him and do it easily. And this bill of particulars is a hell of a start because they have nowhere to go here. Because, and by the way, when we have service of process, that's another thing that comes up because they haven't served us. And I go on and I say, well, from the articles of, if for corporations, the articles of incorporation for a petitioner has petitioner's a designated agent for service of process in the state capital been served. Not possible. If you're a corporate entity, you have to register with the Secretary of State and you have a designated agent, usually in the state capital, quote unquote, and you serve that agent with service of process. That's how you get them into court. If they're treating us like we're corporate citizens, that's what they have to do. They never do it. And that violates what's called the Penoria rule of the U.S. Supreme Court. Penoria v. Neff, 95 U.S. 714. And I'm sure back when they made this decision in the 1880s, they didn't have much of a clue how it was going to be used today because it wasn't common knowledge at the time what exactly happened with that 14th War Amendment. I mean, the Supreme Court itself didn't find out, at least in part, until about 1882. The case is Southern Pacific Railroad v. Santa Clara County, just down the road from me, where they were going to rule against the railroad until Roscoe Conkling, the big fat New York attorney that was on the secret committee of 15 for Reconstruction, told him the intent was to make citizens out of corporations. They didn't know, the people who ratified it didn't know, and even if they had the power to ratify it, and they didn't, the 14th Amendment has never existed. And that's the only jurisdiction these bastards have. So my goodness, and it goes on here, I talk about the elements of the crime. They can't define those either because there are no crimes anymore. They're all federal public offenses. 27 CFR, which is Code of Federal Regulations 7211. They're all in interstate commerce. Now ask yourself, if we can prove there are no states and you get my materials, send me an email, youwinnincourt@gmail.com. They're going to get, if you get the full order, an 83-page brief on admission of new states that leaves nothing to the imagination. there aren't any sovereign independent states left. One of the obvious questions that comes right up, where is the jurisdiction and venue for interstate commerce? And even if it exists, the Supreme Court, there's those pesky 9 old courts again, have ruled that the Commerce Clause powers of Congress are closely associated with the Admiralty jurisdiction, aka to the framers of the Constitution, as a jurisdiction foreign to our Constitution and unacknowledged by our laws. How the hell are we subject to the jurisdiction that was the central cause of the American Revolution, which we did win, didn't we? They can't answer questions like this. There's no way they can do it. So that's why the charges will almost certainly be dismissed. In your case, if you get to a jury trial, so be it, because I'll be appearing there, even if by Zoom appearance at a contested hearing, and educating the jury in a hell of a hurry. And you're going to get an opening statement to make about 25 minutes or so to the jury. That's going to wake them up in a hurry and get through a lot of cognitive dissonance that they're normally subjected to. You know, and the judge gives them the instructions and tells them they're bound by the law. The hell they are. You know, we have our instructions that they'll probably never see, and that's a major jurisdictional error, even in their corrupt courts. That's how bad it is. If we have no right to trial by jury, it's over. There's no constitution, there's no states, no peaceful remedies. And if you're listening, John Roberts in particular, if that's what you think, then you have the sworn duty to tell the American people, and let us take it from there. Damn, I've gone on a bit here, but you get the idea with the big BOP. The Bill of Particulars, the most powerful document we have, and you have a lot more right behind it. It's the old 1-2 knockout punch, just like in the ring, and they can't withstand any of it. That's the power we have, and what I want to teach you how to do. You're going to send me an email, youwinnincourt@gmail.com. Subscribe, like the videos, get the word out. The sooner we all start working together, Asians, Africans, and Americans, the same issues, the same status, the sooner we get these bastards off our backs. Thank you.